Hey everybody, welcome back to the channel. Today we have a little bit of a special thing going on. We have somebody in studio with us. That person is Costas Moros. He is an attorney at Michelle and Associates. Pretty much the guy when it comes to all of the CCW progress that we've seen in communication with the Sheriff's Department. So Costas, thank you very much for being with us today.
Thanks for having me again. It's always a pleasure.
Absolutely, and I definitely want to dig into that CCW stuff. But first, as always, please be sure and like, share, and subscribe to these videos. Hit that little notification bell. It really helps with the algorithms. And guys, the algorithms are helping us as we continue to get more subscribers and more people liking and commenting to these videos. It's getting pushed out to more people. So every time you do that, it certainly helps. So let's just go ahead and dive on into this, Costas. We as far as lawsuits are concerned, haven't really seen too much when it comes to concealed carry in California lately. But what we have seen was the passing of Senate Bill 2, which is going to be coming into effect. That's going to drastically affect CCWs in this state. So I guess before we get into SB 2, I'm just kind of curious. You know, we had the Bruen decision come down. You have, I guess, sheriff's departments that were kind of in different stages, right? We had sheriff's departments that are completely open to CCWs. They've been providing their citizens with the opportunity to get this, and they got high numbers. You had counties that had really low numbers. So in each of those categories, how has it progressed since the Bruen decision in general?
Right, and that's what makes California interesting in terms of CCW, because we're one of, maybe the only state, I'm not sure if New York and maybe one other are similar, but we're one of the only states that CCW permit issuance isn't done statewide. It was actually left by law to each county. So while Bruen changed a lot of things for people in LA or in San Francisco, most of California, like Riverside County, Bakersfield, etc., all these places were already effectively shall issue before Bruen. So while California law had good cause, all these sheriffs, I think the majority of sheriffs said, well, if you just say self-defense, that's enough good cause for us. So that's effectively the same thing as shall issue, right? So now what we've seen is with Bruen, we've had varying resistance among the different county sheriffs. So some, and also police departments, not just sheriffs. So some accepted it and gradually started to change their systems relatively promptly. They were slower than we would like, but they did change it. Others have dragged their feet such that it's taken quite a while to get any permits issued, but CRPA has been on top of them. I've been on top of them, pressuring them, and we've seen some real changes. Before the show, we were talking about San Francisco Police Department, who, San Francisco's sheriff, which I know is distinct from the police department, but the sheriff had bragged the day Bruen came out that he had never issued a CCW permit in the 2 years he had been sheriff. And before that, for years, they hadn't issued to anyone except some high-profile celebrities and rich people and such. And so we got that to change because now SFPD has issued over 100 CCW permits with hundreds more in process. That would have been unthinkable in California before Bruen. And we did that without litigation. We did threaten litigation at one point, but we got that done without a lawsuit, which is always better for us because it's a lot cheaper for CRPA to pay us for our time when we're just sending a few emails over litigating a whole case. So that's the status right now in California. There's resistance among various counties, and not to give away too much, but we do have some plans to address the holdout issues on things like wait times, high fees, and such. Yeah.
Well, so pretty curious. You mentioned that it wasn't litigation, but what exactly is that a product of? You know, we did initially come out and say, you know, with the Bruen decision, we can't necessarily expect anything overnight. I know that we sent letters to all of the sheriffs, basically stating, hey, we got the Bruen decision. It's time to comply with this. While we didn't necessarily expect it to happen overnight, how is this progress made? I mean, is this basically the rule of force, or is there a shift in the mentality of these sheriff's departments since Bruen? Are they getting on the same wavelength as some of the other counties like Solano or Riverside that are actively producing CCWs? Are they seeking counsel there? What can we actually attribute this progress to?
Well, it varies by county. I'll use San Francisco as the example because I was already talking about them, but also Alameda. So San Francisco was going to pass a sensitive places ordinance. I know that's a little bit of a different issue, but this was this past summer. And I sent them a letter also copying the sheriff and the police department saying, if you pass this, we're going to sue you. And also, don't bother because the state's about to do it anyway. Just let us fight it out with the state. Don't pass this for now. Let Bonta take care of it. And then after it's done, if we lose, you could pass whatever you want, right? But in that letter, I also mentioned that the San Francisco is taking way too long on CCWs. So if we have to sue over the sensitive places law, we're going to make the most of it and also take on your wait times. And they backed off. They didn't pass the ordinance. And soon after that, SFPD really ramped up the permit issuance. So the threat of litigation is powerful. Other counties, you don't need to go quite that far. Just constant letter writing and constant, me bugging them all the time will get things done without a formal lawsuit threat. Another one was Alameda, similarly. Alameda, to be clear, I'm still in contact with their county council all the time because they are way too slow. I think they're the second worst in the state after LA County in terms of wait times. It takes over a year to get a permit. But they did, to their credit, change a lot of policies after we threatened litigation. They used to ask you to provide a description of your house layout and the security in your house and whether you had fencing, and you had to provide reference letters, and you had to do this and that, and you could only have one gun on your permit. So all these restrictions were done away with, and now our only real issue with them is the wait times. Another example is the last one, because I don't want to keep you guys here all day, but is Santa Clara. Santa Clara was also very slow, and we still have issues with them, but how they responded, which I didn't even suggest and I thought was very innovative, was they had this big surge of hundreds of applicants. So they took 2 weekends and did a mass interview. So they got hundreds of people done over a couple weekends. I guess they just called in help from people not normally in the CCW unit. And that cleared a lot of the interview backlog. Now, of course, there's the psych exam, which we have issues with, and other steps that are still clogging it. But they have issued dozens of permits now, and we hope to see them speed up as it goes.
Well, okay, so you're pushing in the background for at least an uptick in being able to issue, get rid of a lot of these barriers that are preventing people from doing that. SB2 is certainly that. What in the background are you hearing from the sheriff's departments, or are you communicating with the sheriff's departments as SB2, inevitably comes to that date where it might be implemented if there is no answer that we have from a lawsuit yet?
Yeah, so first of all, I am confident we will have an answer from a lawsuit. We filed our lawsuit actually before Newsom even signed it. We served it on the state once he signed it. We filed our motion for preliminary injunction, and we have a hearing set for December 20th, which is a little tighter than I would like, considering the law takes effect January 1st. However, I am confident we were fortunate enough to get Judge Carney, who was the same judge in the Boland matter, and at least I don't want to predict based on what he did in Boland that he'll do this side with us again here. But in Boland, he was a very thoughtful judge. He was very concerned about Second Amendment rights. So I believe that he will get some sort of ruling out by the January 1st date. Maybe he won't side with us on everything, but I think the worst aspects of SB2, like what I call someone else on Twitter coined, 2A updates on Twitter coined the vampire rule. And we call it that because you have to ask permission before you enter any public place. Right. And that's what really kills the right to carry. Maybe you can, I'm not saying the other restrictions are okay, but maybe you can avoid a library or a park, but you can't avoid private businesses. It's where most people go on a daily basis, the grocery store, restaurant, etc. So we are confident the lawsuit will stop that. But now, long-windedly, to get back to your original question about sheriffs, there's actually nothing going on in the background because they're very public about this. As our lawsuit discusses, they oppose this in the legislature. Several county sheriffs and the California Sheriff's Association opposed SB2, and we have a signed declaration from the president of the Police Officers Research Association of California, which is the largest police organization in the state, opposing SB2, and that's all on the court record. So we have a lot of support from law enforcement. I know the gun control side likes to brag when cops are on their side. Well, in this case, cops are on our side. you know? Yeah.
Well, I'm kind of curious. Would the lawsuit completely strike SB2 from the record? Because the sensitive places thing is a huge part of that, but there were other parts of SB2, right? And that's kind of what I'm alluding to with this question. If there's any further discussion, and honestly, one of the things that hasn't been talked about so much when it comes to SB2 is that law enforcement would have to put a tag as a prohibited person on anybody who's subject to a restraining order.
Yeah.
Now, one of the reasons why we oppose, these so-called red flag laws and all this stuff, because there's no due process. Anybody can go and file for a restraining order on anybody with no due process. So that's a huge, I guess for lack of a better term, red flag for me, when you have a process like that put in place, which would basically eliminate the opportunity for somebody to get a CCW. Do we see any potential answers for these things coming out of SB2?
So the way we looked at it is this, and to be clear, our lawsuit is focused on the sensitive places. So no, even if we totally prevailed, it wouldn't totally strike SB2 yet because we haven't challenged the other stuff. But let me explain why that was. If the sensitive places go into effect as written without any reduction in our lawsuit, then there's no point in a CCW anyway. Like, who cares if you're restricted? You can't carry anywhere, so why does it matter? So we saw this as, let's focus on the sensitive places first, so there's still a reason to get a CCW, and then we will turn back later and address the other problems as they arise, because there's also a standing problem. So we can't just go into court with our plaintiffs who have CCW permits already and say, well, we also challenge the restraining order provision. Well, do any of our plaintiffs have restraining orders? No. Right. So there's no standing. So we have to actually wait typically for somebody to be denied on those grounds and then go in. But I will say that, and again, I don't want to drop too many hits, but an upcoming lawsuit, although not technically about SB2, is going to have questions presented in it that would be a flank on SB2, that if we prevail, it would kill things like SB2's, for example, social media search. That's disgusting, by the way, total First Amendment attack. But the social media search aspect of SB2 as a unconstitutional suitability determination.
So, I guess that's important to understand. There are aspects of the law which you can bring an immediate challenge to. Right. And then I guess, for lack of a better term, there are aspects of a law that you kind of need to have damages in order to bring a lawsuit
Correct.
to.
Yeah.
I remember I don't want to say we got criticisms, but we got a lot of inquiries about when are you going to file a lawsuit on these ammunition background checks? And I remember the sentiment kind of being the same. Well, we don't have anybody who's been denied that yet. So without that, you can't really file a lawsuit. I guess logically, that makes sense. And obviously a good thing. You can't just not have CCWs. So filing on the sensitive places was definitely necessary.
Can I say something real quick about that? You talk about ammunition background checks, so that reminds me, I don't mean to go into a side note, but CRPA a few months back asked for people to share their ammunition background check stories just so we could present new evidence to the court. Mm-hmm. And Chuck said to email me. I got hundreds of you, so thank you for sending those. All those people that I didn't respond to, talking to you, that wasn't out of disrespect. I wasn't ignoring you. I just literally got hundreds and couldn't respond to everyone. So the CRPA community, we love you guys. Thank you so much for doing that. And we picked out a handful of them. We couldn't use all of them, of course. We picked out a handful of them to share with the court. So sorry to diverge in that side note, but I never actually...
Well, that's actually really great to hear. You put that stuff out and... To see it actually get received on the back end is a good thing. Yeah. But I also wanted to get your perspective, kind of as not just an attorney, but attorney specifically in Second Amendment litigation. We've got the talking figureheads for California. He'd probably tell you he's part of a royal family. But, you have Gavin Newsom taking to Twitter or X or whatever it's called these days, basically attacking Judge Benitez. And it's never the first time, right? When Judge Benitez came out with the Duncan decision, when he came out with the Miller decision recently, he's basically openly attacking this guy when you've got different communities in California. The pro-Second Amendment community obviously looking at these decisions as a constitutionally correct thing. You've got the anti-Second Amendment community who might think Gavin Newsom is... oh, he's really fighting for us, putting these guys to shame. I want to know what exactly, from your perspective, do you see? Or is it a combination? Is it one side or the other? Because the Second Amendment community basically comes out and says, "Oh, California's scared. We got them on the ropes. We're running. They're running." So from the eyes of somebody who's specifically working in Second Amendment litigation, what's your reaction when you see stuff like that?
Well, I think Gavin Newsom actually goes further than most. Let me put it this way. I disagree with Rob Bonta on Second Amendment stuff. Obviously, he's our opponent. But I don't actually personally dislike Rob Bonta. Like, I don't know him. I'm maybe I
Right.
would dislike him if I met him. I don't know. But Gavin Newsom is a demagogue and a bully. He's a major bully, and he doesn't even care. He doesn't represent the approximate third of California. Unfortunately, we are a minority, but he doesn't reflect the third of California that is more conservative and that tends to have these pro-Second Amendment views. So, and he knows the political realities in California. He knows the coastal areas are on his side generally, and he doesn't feel the need to appeal to them. Now, the other thing to keep in mind about Gavin Newsom is he's running for president. He hasn't said that, and maybe it won't be in 2024. I think he is. The reason he's in China right now meeting with Xi Jinping, or the reason he's taking these foreign visits and acting like some sort of president, even though he's just a governor, is because I think in the back of his mind, he's worried that President Biden, not worried, but he thinks that President Biden might sometime next year say, you know what, guys, I'm too old for this. I'm going to stop at one term. And then Newsom would probably be the one in line. Sorry, Kamala Harris. I mean, it would be Newsom. So, but even if that doesn't happen, he's lining up for 2028. Clearly, he wants to be the next Democrat presidential candidate. So that's when he explodes on Twitter and bullies Judge Benitez and calls him all these names. That's what you have to keep in mind. That makes him a little distinct from, say, the governor of New York or the governor of New Jersey, who agree with Newsom but maybe aren't this unhinged about it. It's because he's got the Democratic nomination election in mind, and primary voters that are Democrats are generally anti-gun. Not all of them. There's exceptions, but that's what the base tends to want. So you have to, I know you asked me what do I think of it as a lawyer, but even as a lawyer, you have to keep political realities in mind. Sure. When you're doing these sorts of cases, because we aren't, unfortunately, here litigating some boring tax issue. We're talking about a very controversial topic. It shouldn't be controversial, but it is in California. So.
But the sentiments remain, right? So, I mean, do you have to take those sentiments into account? Is California on the ropes right now with the Bruen decision and the lens with which these lawsuits are looking at? Is that really where this is derived from, or is it just a hard stance and specifically personal motivation for a presidential run?
Look, well, it's both. I do think California is in a very tough position right now with its gun laws. The thing they have in their corner is the Ninth Circuit, as we just saw with, I know it's not the subject of today's interview, but the Duncan and Bank, where they took an unprecedented step to try and stop a 3-judge panel from, God forbid, ruling for us like they did last time. So they do have the Ninth Circuit narrowly in their corner because of the President Trump's appointees. It's not as liberal as it used to be. But so that said, they've done a lot of losing lately, and not just he brings up Judge Benitez all the time, but they've lost to several other judges too. I mean, Judge Carney, Boland was his first notable Second Amendment case, and he sided with us. There's been other rulings from other judges. You just had the Ninth Circuit panel, and Newsom said nasty things about them too in the free speech case, the junior sports magazines, which isn't technically a gun case, but it is about gun culture and the First Amendment. And he went crazy on that panel as well, even though it was a 3-0 decision. So California is on the ropes. Newsom is implicitly admitting that their laws are unconstitutional because he keeps saying, this is why we need to pass my constitutional amendment. Well, if your arguments in court are correct that your laws comply with Bruen, why would you need a constitutional amendment, right? You should be able to win in court if what Attorney General Bonta is arguing is correct. So it's an implicit admission that they know their laws are unconstitutional and they need a constitutional amendment to change it, which, by the way, is correct. We agree with that. We agree that if you want to win, you have to amend the Constitution, and you shouldn't win otherwise. Yeah.
Well, I mean, this is something that we're certainly going to keep an eye on. Anything notable coming up, just as far as CCWs is concerned, or are we just sort of looking at the potential for SB2 and the lawsuit there?
I've already dropped some hints, but we hope to be filing something in the next couple of weeks concerning CCW. I don't want to give away everything, but that's coming.
Well, fair enough. We are certainly going to be following along with the lawsuit on SB2. And we're going to have to deal with everything else on the back end, but the future continues to look bright as we do live now under the Bruen decision as far as the lens with which the court looks through this stuff. Costas, I can't tell you enough how much I appreciate you coming by, and thank you very much for being with us today.
Thanks for having me.
Absolutely. And if you like this kind of content and want to hear more about Second Amendment efforts within California, please, once more, be sure to like, share, and subscribe to these videos. Hit that notification bell. It really helps get this information out. And after all, what this is about is getting this information out to as many people as possible so that they can be informed when they go to the ballot box in 2024. Thanks again, guys, and we'll see you on the next one.